right, hey guys, hey, another episode. Welcome to another episode of the Practical Wealth Show. So today's topic is about the stuff y'all been asking me about, which is asset protection, trust, and LLCs. We're gonna go over all of that, the order in which you do that, and but really, let's title this. What has changed in our legal system that makes asset protection so important? Is going to be the framework we're going to build this around. So my special guest today is Mr. Brian T. Bradley. So let me give you a little about him. I'm gonna let him finish, but I'm gonna start the intro. So Brian is a senior managing partner at Bradley Legal Corp. He is a leading educator and nationally recognized asset protection attorney for high-risk professionals, real estate investors, ultra high net worth families, collectively protecting over $5 billion worth of assets. Brian's goal is to give you peace of mind. Okay, that's major, right? Knowing your assets are safe and make it difficult for predatory lawyers to target vulnerable people. Brian, welcome to the Practical Wealth Show.
Oh, thanks, Curtis, for having me on. And this is, it's an important topic. I'm gonna try to keep it not, dense and, legally dense and speak legal mumbo jumbo. I'm just gonna try to, talk plain. I'm not anybody's attorney. I'm not anyone's legal guru. We're just gonna be talking in generalities. And I think that we're really going to learn a lot about just like the different layers of asset protection, how you grow it, when you grow it, and just unwinding the mystique behind this.
Yeah, I mean, what happens is why I'm so excited about this, because people will call me, well, I'm setting up a trust, or Curtis, we know about trust, or I heard it, and they'll hear clips on Instagram or something, but they don't really have their do you need it? When do you need it? So I kind of want to unpack that. So now you have a roadmap of when to do what. This all falls under, if y'all are following, I'm going to put a link into a show called The 5 Principles of Personal Finance. Principle 2 is maximum protection. So all of this falls under our second principle, which is playing defense. Brian, I tell them Curtis is your defensive coordinator, right?
And I think that's important. You got to play defense, but you got to do it before you get in trouble.
That's right. You can't call, this is just on the insurance side, right? Jake from State Farm when your she shed is on fire. Right?
No, exactly. You got to call before the she shed's on fire. Get the insurance beforehand.
That's right. So you got to do all of this stuff when you don't need it, because when you need it, it's too late, right? Correct. And so you've got to set it up. And so, but now what, why, and when? So Brian, welcome to the show. Let's start where you want to start.
Thank you, sir. I think we just start with what, why, and when. Let's just start with the what. I think that's the basic concept, and then we'll go into why. So the what is really what is asset protection, right? It's not traditional estate planning. It's really modern estate planning, and what we're doing is placing legal barriers between your assets and the potential creditor, like the person suing you and trying to collect and take your money or your real estate investments and all of your assets, like you mentioned, before it's needed. And that's really the key word, before. So it's just a barrier, like a safe that you're going to go and put your gold in, or your guns, your valuables, anything of value you want to put behind the legal barrier and out of your personal name, so that it's not going to be easily attached with a lien, or reached. So it's just like the rich. Think of it like the rich. We're there. We want to get there. There's this Tony Robbins saying, right? Success leaves clues.
Right.
The rich don't own things in their personal name. Their businesses and their trusts do. They just get the beneficial use and enjoyment out of them, while separating out the legal liability. So that's kind of the roadmap that we want to start trying to follow here.
I've heard it. Control everything, own nothing.
Correct. But exactly, because if you own it, then you're going to be legally liable. There's no degrees of barrier, but you still want to get the beneficial use and enjoyment out of everything. Like own your yacht, own your boat, enjoy it, but have your LLC own it or your trust own it. You're just going to get the use and enjoyment out of it.
Okay. Yeah. Let's go there.
Yeah. And then I think the why. So, we live in this crazy world, right? I got into asset protection from the litigation and trial side of the law, and having clients being sued and their lives just turned completely upside down, coming to me after they were already being sued. And at that point, you're just too far down the rabbit hole. Like you mentioned before in the intro, it's like trying to get car insurance after you got in a car accident or your house burns down, and then calling, Jake Farm from insurance. There's nothing they can do for you. It's too late.
Right.
And then I see a lot of people that, they don't need to do anything until after the fact, and they're just going to ride lady luck. Well, that's like going to Vegas. It's just gambling. It's wishful thinking. Or they think that their insurance, like you mentioned, is going to cover them, which unfortunately, like really big cases, like $1 million lawsuits, it won't. It's important to have insurance. You need insurance, and you need good insurance. But we're getting more and more claims that are radically in excess of your insurance coverage. So being underinsured is a very big problem.
Mm-hmm.
Or you forget to level up your insurance as your wealth levels up, or you forget to get an umbrella policy, which are all entry level, base layer ways of asset protection. But people think an umbrella policy means that it's just going to cover everything else, and it doesn't. It really just provides more coverage, like excess coverage, with the same escape clauses. For example, like they're not going to cover you for fraudulent unintentional wrongdoings. So that's immediately going to be an argument for a multi-million-dollar case.
You said fraudulent, unintentional.
Fraudulent and intentional.
And intentional. Okay.
Yeah. And so like any type of lawsuit is always going to have an element of fraud or intentional wrongdoing. Okay. And that can literally just be like, I typed an email and clicked send. And then when you present an email in front of a judge, it's going to be deemed an intentional act. Whether it's like, yeah, the plumbing was done and then the plumbing exploded and caused a $10 million, lawsuit. Well, the act of sending an email is an intentional act. So now the insurance has legal wiggle room to say, well, now there's the deemed intentional act and wrongdoing on this. We're not covering you for that. And if you think you're wrong, go ahead and sue us. That's how the insurance game is played. That's why they have, insurance defense attorneys. And then another really big one is that they think that their estate plan, also known as like a revocable living trust, is going to protect them, which it can't. They're not designed to. And that's what we're going to break down later on, like the different flavors, like Baskin Robbins, the different types of ice cream of trust. Right. And so just realize you need to have a revocable living trust for, avoiding probate and estate planning purposes, but those are not asset protection trusts. They're not designed to protect you, so they can't. And then we have other really big misconceptions to break, like LLCs. A lot of people think all of a sudden that LLCs are this one-stop silver bullet, but they forget first word, first letter, limited. They tell you straight up in the name, these are limited. And the sad thing is, if you just look around, the legal system is broken. We're literally living in a sue happy nirvana right now.
Yes.
And I think if you don't mind letting me like set the stage on this a little bit further, because then we really add context to what we're actually fighting against.
Yeah, do your thing.
The legal system's drastically changed over the last 40 years. It's no longer about justice, but it's about redistributing your wealth from the haves, which is you and the people investing and buying properties, to the have-nots. What about, over the last 40 years, things that didn't happen in the past or that weren't even allowed to happen in the past, like contingency fee lawyers or law firm advertising, they're commonplace now. And this thing created a cultural shift of a predatory legal system that, again, is not about justice, but is purely profit driven. And then you get in the world of high net worth and the affluent families and wealth, kind of like the world that I live in. For my clients, this level of protection, we now have to actually deal with taking like a more macroeconomic global look. And so when you step back, the big picture really is that we have this global financial system that has structurally deep-rooted issues, right? Along with government-backed fiat currencies that are now in question. And this also includes the US dollar. And we have monetary policy, policies today that are, it's just very simple to see, like we're going to inflate or die.
Right.
And then we got governments looking for deep and accessible pools of financing, meaning your money and your assets. And then along with, financial repression, monetary and economic manipulation. And all this is just adding more and more challenges to actually protect your wealth. And so asset protection is now your modern best bet to level this crazy playing field that we're in by using all the different legal tools and strategies that we're going to break down today. And then what this does when it's done properly is it gives you peace of mind, and then it gives you lifestyle preservation, because then we're really just focusing on, no matter what doomsday lawsuit comes your way, it really comes down to a matter of just how collectible are you. And like you mentioned before, like we have over 3,000 clients nationwide protecting, multi-billions worth of assets. And so we want to make sure that the structures that are created are actually created to be efficient and effective.
That's that. And I keep going, because I had a question. I'm gonna let you, because it's there, what you should be hearing, there's layers to this stuff, and you grow as your business and personal economies grow. And like, I didn't know like the difference. So let's bring in a point here, because so on the estate planning, I'll hear people in my industry, in insurance, estate planning, you need a revocable or irrevocable trust, and you can, bypass probate. And a lot of times you can make life insurance is funds the trust. Like, you can make the trust the beneficiary of life insurance, but that's not asset protection. That's a whole different thing.
Yeah. So that's estate planning for when you die and you pass, to how to pass the assets that you want to, like, your kids or your grandkids and whoever it is, without the states getting involved in this. It's called avoiding probate. Okay. And then back in the day, it used to also help with death taxes, but now that's mostly irrelevant, because the marker for when you're even going to be taxed is so high. Most of the people aren't above the like multi-million-dollar threshold mark. So your assets will pass, tax without being taxed with the death taxes. That could get changed. Who knows? Like, it's going to be different for every administration. But right now, you're only talking about the 0.01%ers who even have to worry about that aspect of it. So your estate plan, like your family revocable living trust, is just there to avoid probate. That's it. Identify who gets what, get your medical directives, financial directives. It has no ability to protect you whatsoever. I'll break the trust down after this, because this is kind of like, that's the last layer of protection. Yeah. So if we want to talk about like key concepts and layering, I think a really good way to go about this is, I want you to think about winter. Okay. So when it comes to asset protection, we have different layers. The first entry layer is your base layer, and it sits on your skin. Okay. This is an LLC in insurance. This is when you're just starting out investing, and you're going to probably have 0 to 3 units, or 0 to 3 properties. And your net worth is generally going to be at $250,000 net or below. And then as you grow and you add more assets, you hit around that 4-unit mark, or you're investing in multiple states, you're generally going to have around, at this point, 500,000 to 700,000 net assets. This is where you want a mid layer, which is usually a little bit thicker. It's going to be made out of merino wool, like a sweater or a cardigan for you ladies that are listening. This is a management company. We use a limited partnership for this mid layer, which I'll break down if we have the time for that. And then when you hit around that 1 million net worth mark, you want an outer shell waterproof layer. This keeps you nice and dry and warm when the weather's really bad. This is your doomsday lawsuit protection layer. That's your asset protection trust. And depending on, the client's need or profile, we're generally using a hybrid trust, which I'll break down, but that's a combination of an offshore trust domesticated through the IRS. But by layering, you're now more flexible. You can adjust and make yourself more comfortable. You can take the base layer off. You can take the mid layer off. You can take the outer shell water layer off. You can mix and match as you need it. You want the same thing as, with your asset protection plan. And so for all this stuff to work, 4 things are going to have to be true, right? First, the system you're going to create needs to be impenetrable. Second, it must be managed properly. Third, the plan cannot attract a lawyer to want to actually try to challenge it, thinking that they're going to get a payday by piercing the veil. And then fourth, it just has to work. So then as a client, when you come to me, I know 4 things that need to be true on my side. 1, you want an effective plan. 2, you want to control your plan. 3, you want a reasonable and sustainable cost. And then 4, you want a plan that's easy to maintain, compliance on with the IRS. And so as you go through the evaluation process of, how good an asset protection plan is, I think like the best way to do it is remember the acronym ECCC: effectiveness, control, cost, and compliance, because we want all 4 of those to be check marked off once you create your asset protection plan. And so I think like a good way to hear is, maybe like start, like maybe do a couple misconceptions of LLCs and kind of like go through like, okay, here's the base layers. You want to break?
Absolutely.
There.
Yep. Because everybody thinks that's the panacea. Like I'll just set up an LLC, and that is not. It is. I mean, I think it's an asset protection thing, not a tax thing. That's what people think. And so to me, you should have a discussion with somebody like you, looking at this whole thing, and then but layering in. So go ahead and finish this conversation.
Right. Yeah, no, I it's been this weird shift I've noticed in the mindset in the last like 4 or 5 years, where before people realize limited liability company, like emphasis on the word limited. And then all of a sudden there's this new mindset of, well, we're going to disregard the like 40 years of case law and piercing corporate veils. And now like the LLC has this new dragon slayer mindset, like, all you need is an LLC and you're perfectly fine. Completely not the case. But let's just break down this first layer. The first layer here, asset protection 101 is, like I mentioned, the entry level base layer. Most of you are familiar with it. It is the LLC and insurance. Anything that has a key or that needs insurance or that can go boom and hurt somebody, it should go into an LLC. How many is just going to depend on the client's profile. We all know about LLCs, so I think that we should just talk about more of the misconceptions and just like relate it to the first acronym I told you, like effectiveness.
Okay.
The first problem generally is that most clients have single member LLCs and they're all in your personal name. The problem here is that courts now have a tendency to completely disregard single member LLCs. So when your corporate veil is pierced, it's not effective at all, right? And CPAs tend to set up LLCs as disregarded entities for tax purposes. That's great for taxes, but it's really bad for lawsuits. What being disregarded means is that the IRS is not taxing your business separate from you. It passes through to you personally. And because of this, they're basically worthless for asset protection and lawsuit issues because that liability also passes directly through to you. But don't get me wrong, like I still use LLCs, but again, remember, I use them at the base layer entry level protection. And then as we need to, I scale and layer the protection up from there. So it just depends on where you're at. If you're just starting out, something's better than nothing, right? You're going to start with LLCs and insurance.
Right.
And then the next layer, those LLCs would be owned and flow into a limited partnership. And then you're going to get more protection through that limited partnership. And then when your limited partnership, like that management company owns all your LLCs, the benefit of that is now you actually are only going to have one tax filing all through that management company. Not like, let's say you have 15 LLCs. Well, instead of doing 15 different tax returns and K1s on all these different LLCs, by having them disregarded into your management company, now it's just one tax filing through that limited partnership. The second really big problem here is just a confusion on like, where do you even go and set these LLCs up in? Like, do you go to Delaware, Wyoming, Texas, Nevada? Like you hear a plethora of different people saying different things. And I think is causing a big misconception on this. It really comes down to an issue of just what are you holding and where are you holding it at? And attorneys and CPAs are really convoluting this up. And I think particularly because they're just selling one product and not talking about the cons of things. So let's say, for example, and I pick on California a lot, is California real estate that you own and you're a California resident and you set up a Wyoming LLC. And then you go and you hold a key piece of California real estate in a Wyoming LLC, and you're paying California franchise tax on that out-of-state Wyoming LLC because you have to pay the franchise tax. What you've done is just convert your Wyoming LLC to a California LLC because you're doing business in the state of California. You're paying the franchise tax in California. But if you ever have a liability issue in California, meaning a lawsuit, you're getting sued because you hit somebody with your car, or you're getting sued through the property and that property is based in California, or that property could be based in Tennessee. The judge in California is going to apply like that California law if it's a California property, not Wyoming law. This is because a judge in California or any other state doesn't care that your LLC is a Wyoming registered LLC. What they care is that it's doing business in California. It's done this big legal word called availed itself of the protection and laws of California. That's the state that assets in. That's the state that injury or damage occurred in. It's going to be that state's laws that are going to apply. You don't just get to take Wyoming or Delaware tort and damage laws and personal injury laws to another state. That's not how our legal system works. So though you thought you did yourself a favor by setting up like a Wyoming or Delaware LLC to hold your real estate in, you can't just go and purchase another state's better laws and then bring them to a state that you have no jurisdictional connection to. So for assets that are real estate, specifically real estate, I recommend using the state that the real estate is located in because you're not gaining anything by using another state. You're just doubling your maintenance costs. And this is where the KISS principle, keep it simple, stupid,
right,
really comes into play. Then you just add those LLCs into your management company and clean it up for tax purposes. The final big misconception of this base layer LLC is this fancy word you're hearing everybody fall in love with called anonymity. All right. And the thought here is that you can just create an anonymous Wyoming LLC and that you can just like completely disappear and ghost a lawsuit. And this is just completely false. But I get this question every day. When your LLC is sued, you're going to be legally required to appear and defend it in court. You also have to have what's called a personal agent of service. That person or agent's sole job is to actually serve you and say, hey, congratulations, you just got served. Then you got to get your butt in court and defend yourself. Also, the simple reality is that once a lawsuit is actually filed, the legal discovery process in court begins. And what's even worse is that if you want secrecy to even work, this is also known as lying under oath. That's going to be a one-way ticket to jail. An example of this is that the creditor suing you, they have the legal right to demand information about the assets you own. And the courts enforce this right very broadly, especially when you're not in the South. So think about anywhere on the East Coast, West Coast is going to be enforced very broadly. So at this point, the only way to keep an asset, air quotes, anonymous or a secret is to lie about them and commit perjury. That's not good because, again, people go to jail for committing perjury.
Right.
So I don't advocate for hiding. We just prefer to have a, very full, strong asset protection plan and full disclosure of the assets and just set it up in the proper jurisdictions to work. And then we're setting up, at that third layer, very strong asset protection trust, because that third layer, again, that's the outer shell waterproof layer. Like that's really where the magic starts to come and happen.
That's brilliant. Okay. You just busted so many myths I've heard on, you got to get Wyoming, you got to get this, you got to get, Vegas thing. And you think that you're hiding this stuff. And what you're saying is that's not necessarily so.
Well, it's not, because just think about it. Like you go and create a Wyoming LLC. The only way to actually have a Wyoming or Delaware or out of state LLC is you have to have an personal agent of service. Otherwise, you don't even have a legitimized LLC. So what is their sole job? To say, hey, Curtis, guess what? We just got this notice of service in the mail for a lawsuit. You're served. Now you have to go and get a lawyer and show up in court, or you're going to get a default judgment. So you're going to show up in the court and the judge is going to say, okay, like you're the member of this, you own this LLC. Yes. Okay. What assets do it own? Does it own? At that point, you're either going to say it owns nothing and lie and commit perjury, or you're going to disclose the assets. Well, where's your anonymity and privacy at that point? It doesn't exist. So you need to realize anonymity is a privacy mechanism from harassment. So people can't say, hey, Curtis is my landlord. Curtis lives at 123, Main Street. I hate Curtis. Let's go egg his house. That's anonymity, privacy, not ghosting lawsuits and hiding assets.
Okay. Good distinction. All right, let's go, keep going to the next layer.
Yeah. So the final layer is this, true, full, bad weather, the outer shell layer, it's the asset protection trust. And it's the heart and soul of an asset protection system. And trusts have been the longest lasting entities of all entities, for holding assets. When it's done right, they're very strong and can be sculpted to fit how you need them. And they can morph as you need them without dealing with funding issues that you see with LLCs or like other business entities that get them pierced. So I just love trust. And then having a trust at the very top of your planning is very powerful. And this is where creating an asset protection trust, and more importantly, picking the proper jurisdiction, comes into play. And just like Baskin Robbins, trusts come in lots of different flavors and types. The standard 101 trust that everybody's familiar with, from the 60s, you heard us, talking about a little bit earlier, is the family revocable living trust. Trusts don't die, so that when you do, and you actually funded your trust by transferring ownership and title into it, you don't have to go through the courts and probate, and it changed the landscaping of estate planning. Then you also have, and some of you have probably heard of land trusts for real estate, that holds your land and you connect them to LLCs. But land trusts don't have any protection in and of themselves. They're only as strong as the LLC that they're connected to. And land trusts are just privacy mechanisms, or not protection mechanisms. From there, you have higher levels of trust that are called asset protection trust. And this is where I think I really want to spend the time and break down the three different types. And after this, I think you and your listeners are going to probably know more than 99% of all the attorneys out there about asset protection trust.
Let's do that.
All right. So yeah, let's break it down. It's pretty interesting. So these asset protection trusts came about in the early 1980s. And An asset protection trust is what's called a self-settled spendthrift trust. So all self-settled means is that they're created for yourself. So they're for you, by you, as your own beneficiary, and they have very important spendthrift provisions in them. This lets you protect your assets while you're actually living from creditors, not having to relinquish the control of your assets. The difference is that they allow you to protect your assets, not just for your grandkids, but for yourself, which you weren't allowed to do in the past. And you're probably somewhat, again, familiar with the other type of self-settled trust that I mentioned, the revocable living trust.
Mm-hmm.
Maybe you have them, or your family members have them, grandparents have them. They're the same in that they're self-settled. They're created for you, by you. The difference is that with an asset protection version of this trust, it includes these critical provisions called spendthrift provisions. What spendthrift provisions are is they are provisions that allow you to protect your assets from the creditors, the people suing you. So they're the actual teeth behind it. And for those to work, the trust has to be not revocable, but irrevocable. So it's actually a very different type of trust altogether, just like chocolate and vanilla, right? Like they're both ice cream, they're just different types of ice cream. And then this is where the fun really starts to happen. There's two major schools of thoughts. There's international and domestic. So you can set them up here in the United States, or you can set these trusts up offshore. And if you don't mind, like I'd actually like to break them both down from a historical context so that your listeners actually understand like what the components are and why we even care.
Yes.
All right. So we have, again, those three options. You can go domestically, you can go offshore. Then there's this beautiful thing called a hybrid, which is combining the best of both. So for the historical context, the offshore trust came first in 1984 when the famous Cook Islands created an asset protection trust. I personally like and choose the Cook Islands when it's applicable, just because it offers literally the best home court advantage.
Mm-hmm.
Why it's the best is because asset protection is what these trusts in the Cook Island statutes are specifically drafted for. And the power of the foreign Cook Island trust is that it has this magic thing called statutory non-recognition of any other jurisdiction's court orders or judgments in the world, including the United States. What this means is that if you have a judgment against you in the United States and you took it down to the Cook Islands, your US judgment is literally worthless. It has no value whatsoever. Statutorily, the Cook Islands are prohibited from recognizing it. So if somebody wants to sue your trust in the Cook Islands, they would have to start their case all over from scratch. The person suing you would have to prove their case beyond a reasonable doubt. So that's the murder standard, the highest legal standard in the world, the 99% sure standard, not the 51% preponderance of the evidence. I'm not sure, maybe let's just give it to them standard here in the US for civil cases. You can't get a contingency fee attorney to represent you because they're not allowed down there. It's unethical in the Cook Islands, just like it used to be unethical here in the United States, but that got changed in the 60s. The claim, meaning the lawsuit, it's not amendable. So what this means is that once you file your complaint, that's it. You can't go and change it or amend it after the discovery process like you can here in the US, and then to decide to completely change what you're suing the person for. The person suing you, they're also going to have to front the entire court costs plus flying a judge from New Zealand. And if you lose, you pay. And so this is one of the single worst things that we do not have here in the United States, that the loser does not need to pay the legal fees of the cost of the winner. So if you get sued by somebody for a completely bogus reason, I mean, just a completely frivolous lawsuit, and you spend $200,000 defending yourself in legal fees, and then finally the court throws that lawsuit out, guess what? You're still out $200,000, right?
Right.
That person that sued you is not going to be given the bill, because in our legal system, here in the US, that would discourage lawsuits. And our legal system is run by trial lawyers who don't want to discourage lawsuits. And then not to mention, there's only a 1-year statute of limitations. So all sounds great, right? So we're going to compare this to those 4 things the client wants.
I'm getting pissed off as you.
What's that?
I'm getting pissed as you're,
Right.
because, even if like in lawsuit, even if you win, you lose because you still have to defend yourself. I mean,
you still have to defend. Yes, you still have, and then you're still out that money, and no one's going to be getting it back to you. It's just the way our system is. It's designed for people to sue everybody, fair access to the courts. And so again, let's go back to that 4-part test I told you, like effectiveness, cost control, compliance. Number 1, effectiveness. I mean, the foreign asset protection trust, 5 out of 5 stars. I mean, statutory non-recognition, right? Everything has drawbacks. So what are the drawbacks here? So we got control, cost, and compliance. On these, it actually falls short. The cost will be high. Purely foreign, generally you're talking about $45,000 to $75,000 a year, a time just to set up, plus $10,000 to $12,000 a year to maintain. So the cost is very high.
Mm-hmm.
And if you're purely foreign, you now have a lot more IRS reporting, compliance, and disclosures to file every year. You got to do the 3520s, 3520As. Those are full balance sheet disclosures. Plus sometimes like that, the entire trust agreement has to be disclosed with the IRS. You're going to have potentially additional compliance with FACTA, which is an account tax compliance.
Mm-hmm.
So it's just a lot on there that you're going to have to do. And you're going to be out of control on your trust, because it doesn't work if you're in control. That's why those foreign trusts work so well. And so many clients, they're just not comfortable with all of this. So while you literally have the most effective trust in the world by far, it's not something that we generally are using or starting out with, because of the fact that we have those three drawbacks, which then goes to the second option, the domestic asset protection trust.
Mm-hmm. And you don't have the money, to do it, let alone maintain it. You might have. It depends on who we're listening. So
it depends on who, and then most of the time people just get tired with the IRS compliance. So they'll deal with it for 2 or 3 years, and then they just get tired of the IRS compliance, and they just say like, we're done with this. And then they stop maintaining it. And then you no longer have an effective foreign trust because you're no longer doing the compliance.
Wow. Mm-hmm.
Yeah. So then you got the domestic side, right? It came into play 10 years later, of all places, in Alaska. Then, not to be outdone, you now have, Wyoming, Delaware, Nevada. We have about 19 states with some sort of domestic asset protection trust statutes. So the states started jumping on board, seeing that our legal system is now a threat and that things just need to get done to protect your assets. And so asset protection in the United States is very valid. So asset protection as a concept is very important for you to understand is valid. It's just how you do it is really where it gets important. The issue with the purely domestic or US-based asset protection trust is that we live in the United States of America. We have a constitution. We have Article 4, Section 1. It's called the Full Faith and Credit Clause. This clause provides that every state must grant full faith and credit to the judicial proceedings of every other state. This means that, for example, Nevada can pass an asset protection statute, which they have, but it cannot ignore a California or a Wyoming, Florida court order. So where the Cook Islands can literally just throw that California judgment in the trash, Nevada cannot. Nevada would have to respect it constitutionally and even litigate it. And now the courts are simply ignoring the choice of law clause. We have a lot of cases. What is it? We got, like Bately versus Morrison, Henry Hubbard, Kilker versus Steelman, Dell versus Dale. Just tons of case law of judges just completely ignoring the choice of law clause. So the legal landscape is shifting again, and failure means breach and assets lost. So that is just completely unacceptable. And so because of the case law we're seeing, I'm not a big fan of a purely domestic asset protection trust or anything purely domestic without a built-in offshore component, which then brings us to that hybrid version called a bridge trust.
Let me say, so I'm not going to go on a libertarian rant here, but it's important that, because the Constitution is supposed to be enforced, not interpreted. Mm-hmm. Right. And so you'll have people that are legislating from the bench, but unelected people legislating from the bench, of what their opinion, they want to help out the little guy and all this stuff. And, all right. So you said another trigger, but I'm going to let you keep talking.
Well, no, I mean, you see what the trigger is because you see the system that we're in. It's a judicial oligarchy.
Yeah.
And so like it's a whole episode for a whole nother topic, man. Like we can probly go on days.
Don't get me started with the we just hired 87,000 IRS agents.
Yeah, I wonder what they're going after.
Right. We're gonna go after the rich. There's not that many rich people that are. Don't get me started with that. So this is really important. I don't even know you can protect yourself from them because they're. So
we got cases where we actually can. That's a U.S. first grant case going after the grants for like 36 million in IRS. Tax penalties and money owed, and their money was perfectly safe. And so, but then we get back to like, okay, we see the world we're living in, right?
Right.
Foreign, very, very effective, but we have these drawbacks.
Right.
Domestic, cheaper, right? No IRS compliance, but effective Now, not at all, not effective at all. So what do we do? Okay. So that's where the hybrid options come into play. It came into an existence about 28, almost 30 years ago by my partner, Doug. And what we're doing is just combining the best of both worlds. It's been around, like I said, for a while, almost 3 decades now. And at the end of the day, it is a fully registered foreign offshore asset protection trust with all that 40 years worth of amazing case law. So it's fully registered offshore from day one with an offshore trustee in standby, just in case you need them. But we build the bridge back to the IRS for IRS tax purposes so that the IRS classifies that offshore foreign trust as a domestic U.S. trust. And we do this by complying with USC section 7701. So it's like having 2 passports. You can have your Swiss passport and your US passport. And as long as you have your US passport, the US will always consider you a US resident. So because of that bridge, as long as we have our compliance, we stay classified domestically. And what this means is that the trust is cheaper. It's more flexible. You have none of those annoying IRS compliances, really no IRS tax filings and disclosures at all, while the trust is domesticated, because it is now a domesticated US grantor's trust. But now you get the power of offshore if and when you need it. It's now in your toolbox, just like a contractor building the house. I have all the tools now. I just don't need to use them all at the same time. And so what this does is during a state of duress, like a doomsday lawsuit, your attorney would declare a state of duress. We would break compliance with the bridge with the IRS by removing you as the trustee at that point. And so at that point, the trust is now what it is. It is now that purely foreign Cook Islands trust. So the hybrid trust is extremely effective. You maintain control of the trust right up until that last second where it's not in your best interest to maintain control. The costs are going to be more reasonable. And then with maintenance and compliance, there is none while it's domesticated. So it's kind of that best of both world options. So as you scale, because we're all talking about how we scale into this, so you're starting out LLCs and insurance. As you grow, then you're going to add that limited partnership management company, clean up your accounting as well, 1 tax filing.
Right.
Then you start turning the corner over 1 million unprotected net assets. We put the topper on with the asset protection trust.
Wow, I love that. So I'm thinking about a person, and I now you realize you don't know what you don't know. So I had a person, I had like, I don't know, $3 million worth of real estate, not that much liquidity. No. So I started there all in LLCs. Right. But I said, but no, what's it called? Umbrella coverage.
Yeah.
So I said, all right, listen, you need to call your person, or I'll get you a person. You need to get a quote for, really, I told her 2 million, at least it's 2 million of umbrella coverage. But I don't, but all the different layers you're talking about, I'm so, Brian, you know how excited I am to get this information out there, right? Because there's so much stuff that people need to know this stuff because as you become more successful, there's a bigger target on your back.
Well, there is, or you can be a new, what is it, like out of medical school. You just got your white coat. You're now out of residency. You don't have much money, but you're driving your BMW because you're bad with money, and you decide, like, I'm no longer a resident. I got my big first paycheck. You go buy your BMW, wearing your white coat to work, hit somebody with your car fender bender. You don't have a penny to really rub together, but you're a mark because you're wearing a white coat.
Right. Right.
So it's just a society that we're living in. Like I had this situation happen, like California resident, he's a doctor, got sued for malpractice, $4 million lawsuit, $2 million malpractice coverage, $2 million umbrella. The malpractice covered their 2 million. The umbrella covered, air quotes again, their 2 million. Then the umbrella policyholder countersued the doctor to get the 2 million back because they decided he should have got additional coverage on top of the umbrella policy. So, then, like, if you don't like it, sue us. So while he's getting sued, now he's going to have to sue his insurance coverage provider to try to get the money that he's supposed to have access to. So now he's fighting a double-edged lawsuit.
Wow. And then I could also see some smart aleck will say, all right, well, the agent or the broker, well, why didn't you give me this?
Yeah.
You know what I mean? Which is why I don't want to do that type of insurance, because that's because I'm able to do it, but it's like license wise, I'm like, I don't want to do this because there's too many things I don't know unless you do it full time. And even then you can still mess up. That's why you have E&O, but you don't want to use that either. But anyway, wow. Okay. So is there more? I have some questions, but I want you to finish the layers out. Or we did.
No, I think we ran through the layers are great. So like shoot your questions on over.
So actually I love it because you gave the different layers of what I was thinking about as you're going through this. At what level? Because I've got new people that are working, got 2 or 3 properties, and I've got people that are doing well, 50 doors, 100 doors, that kind of stuff. And it seems like they need to start to restructure their stuff to think about what you're talking about. And then I got small business, let's say, so they've created they have a business that's doing all right, and then they've created a second LLC. Right now it's a single member, and so the idea you just gave me was, okay, so the other one's doing, let's say, $300,000, $400,000, $500,000 a year. They expect a new one to make 6 figures. And I was, thinking about and talked to him about, okay, well, maybe you should get with your accountant. But accountants, there's 2 sides of this, right? There's the tax thing, and then there's the asset protection thing. And you really they need to be in the same room.
Everyone, you need to talk together. And then just think about the principle of your CPA should just be talking about how to mitigate your taxes. That's it. The problem, though, is also some CPAs will start dabbling in legal advice, but not give legal advice and say like, oh, just go create an S corp. Well, let's tap the brakes on this for a minute. Like, what's the asset? And I run into this probably like phone call like once a week. You come to me with $100 million worth of real estate in an S corp, and then you realize, shoot, if I get sued, like all this tied up, like that's bad. Well, I may not be able to do anything from you now because you listen to your CPA for tax mitigation purposes, which is great, Pat, with the S corp. But if I'm going to take all of that real estate, that 100 million out of the S corp to put into the LLCs and the asset protection plan, well, now you're going to owe a massive check back to the government, and deferred taxes and all of that. And most people don't have that type of money sitting around.
Right.
So now, or if you got sued and I had to do it anyways, and you don't have the money to pay the IRS back, there's nothing I can do for you. And so that's where they need to realize the order of progression, or I would say like rules of engagement, should always be protect your assets as strong as you can when you're starting. Then talk to your CPA and wealth managers about them doing their magic on tax mitigation from the structure that we created. But you don't go to your CPA saying, hey, I need tax mitigation strategies and protect my assets. Like, that's the wrong order of operation. And the reason is, if you get sued and you lose everything, what are your CPA going to be filing taxes on anyways?
Right. So let me ask you this. So in the order, let's say I'm building, because I've heard different things. Well, and I know now I'm seeing it depends on the perspective, right? So, hey, you should get 10 properties in your name because you can get government-based mortgages and just get umbrella coverages and just own them personally, so you can get more debt, versus starting them and putting them in LLCs. Well, it's 3 questions, right? Put them in LLCs, and then the question is, do I have an LLC for every property, or do I group them together? Those are some of the questions.
Yeah, that's a good question. So there's different rules of thought on this. Like, some people will say just put 1 property per LLC. I think that's overkill. It depends. And like the lawyer, it depends, right?
Yeah.
Sometimes I do rule of thumb, like the way we do it is I like to see no more than 4 doors in 1 LLC, and I like to keep the equity below 500,000. Sometimes that's just impossible to do. Like, let's say you're investing in anywhere on the West Coast or the East Coast, and it's like you can't even get a property for less than $1 million in a lot of these places. So it's going to be virtually impossible. So in that case, I would say let's try to keep it at like 2 single families and keep the equity below 1.2 million. Just because of where the property is located at. If it's commercial needs to go into its own LLC. All right. Okay. If it's a large property, like you have like a 6-plex and things like that, that should realistically go into its own LLC, because I'm looking at doors. Each door is a lawsuit. All right.
Yep.
And so if it's like we're investing in some of these cheap places where you can go to like get cheap properties in like Ohio, Indiana, and we're getting, 4 units. I got 4 doors, like 4 single families, and each property is worth like 75,000. I would say like I'd be comfortable putting 4 properties in 1 LLC, but putting the cap at that. Okay. So you got to find the right balance of where can I stretch and get a little bit of extra use out of the LLC, but not be stupid about it. Don't put 10 properties in one LLC and front load it with a lot of equity. And at the same time, I think putting, one property in each LLC, especially if it's a low value property, well, then you're stacking up LLCs for no reason. So you got to find the kind of like the balance and sweet spot.
How often should they be conversing with you or somebody like you in their life, like during the course of a year?
So I at least do an annual phone call with our clients. And then I want to know what the heck is going on before it's going on. Like if you're going to buy something or sell something, call me, tell me what's going on. Cause I need to know how I'm going to change and transition maybe the buckets or not, or maybe I need to add something. If you have a whiff that you're going to get sued, like you hit somebody with your car or a deal's falling apart, call me then. Don't call me after you get a judgment in the mail, because I want to be able to have time to think and process and see what I need to get done. Just like you should be talking to your CPA, not just when you're filing your taxes. You should probably be talking to your CPA quarterly, or like, hey, I'm going on vacation, or I want to go on vacation, because then they can kind of like sandwich plans so you can write your vacation off. So the more you're involved with these people in your world, like, the more money you're going to make. You may have to pay a little bit more service, but guess what? By utilizing our knowledge, we're going to save you a heck of a lot of money.
And it's deductible.
And
and business is a team sport. That's what I want them to get them to see. You need to be talking. You need to build a team of advisors and talk to them. And in a perfect world, they'd be talking to each other.
Correct. And you have to make sure that everyone checks their ego at the door. And I always equate it to this. Like if you're sitting at, your round table, you should always be the dumbest person at your table.
That's right. That is my goal all the time, is be the dumbest person at the table.
Yeah. If you're the smartest person at your table, get up and go change tables.
That's right. You need a new table. Here's another question I get is, so I do, life insurance, infinite banking, that type of thing. So I'll get people call me. All right, I'm setting up a trust, and I want to put some variation of, I want to put the insurance in the trust, or we can make the beneficiary. I can make it do whatever you want to do, but is that what you should do? Is my first.
If you're in the South, generally, like those insurance policies, they have great exemptions in like Texas. But if you're not in Texas, I guess like one of the only states where I think it's like almost 100% exempt. Other states it's like 10,000, 12,000. So you want to put those policies either into the limited partnership, like the management company, or the trust. And that way, at least it's protected. Yeah. So you absolutely, but remember, if you put it into your revocable living trust, it's not going to protect you.
Interesting. So that means the cash value, because I know like California, the cash value is protected in a lot of states, Texas, Florida, and completely, right? Yeah. But so if let's say they have because I'm thinking about, I'm gonna have to call you offline. I got some people to introduce you to, right? So if they have 4 or 5, let's say 4 or 5 properties in the LLC, they're going to create another 3 or 4 by multifamily. And then because I teach people, or I've been trained to, all right, you need to you need to hold the policies personally.
So then you just add the LLC as an additional insurer.
Owner.
Yeah. So you just add the LLC, like instead of just having your name as the owner of the policy, you just add the LLC as an additional policy owner in there.
So like a owner, co-owner.
Yeah.
Boom.
Yeah.
Okay. That's simple. That's
really
easy.
It's really simple.
Yeah. It is really simple. So see, when they call me, it's like, all right, I need to know what to do. I can do it. That's just paperwork. That's nothing. But why, and I like to know why, and make sure that people are, because they're getting sold a course or do this, and I'll set your LLC for you up. They don't have any operating agreement. I mean, it's just people wanting to hear, I can make $500, charge people to set this thing up.
And that's a good question. There is like, I get this, like, why I can go on like LegalZoom or some of these guys and like create this. Why should I pay for you? I'm like, well, they're not lawyers, first of all. And then the operating agreement is only going to be as good as like the person. So when you're getting sued, and you're getting sued by a lawyer who's going teeth and nail, like looking through every word in your operating agreement, and most of the time you create an LLC and don't have one, you're pierced right there, right then and there. Then how bad is your operating agreement? Most of the time it's crap, is really bad. And so that's the difference between having a lawyer do it, who's going to pay attention to the nuts and bolts, because I'm expecting a shark to come and attack you. So this is the importance of having the experts do their job.
Let me ask you, all right, so on that point, if let's say you did that, can you go back and have somebody look at and fix your operating agreement? So
you can most likely I would just recreate, the LLCs. If for my clients that are going into like a limited partnership and the trust, I don't care how bad your LLCs are, because that's not where the protection is coming from. It's really coming from the bridge trust. So I'm just going to merge your existing bad LLC into the limited partnership. And then it's really the play off of the limited partnership and the trust where your protection is going to be coming through. So I'm really not going to be revising and amending your LLC, except removing your name and putting the name as a limited partnership as the managing member. But that's about it, because that's not where our protection is coming from.
Oh, this is so powerful. All right. Brian, I'm respectful of your time. We could do this for 2 hours. I'm gonna have to bring you back like quarterly. Okay. But what did I ask you that you want to get? So we should get out there and then tell them how to reach out to you.
I would just say, remember, your protection has to get set up before. So if you're going into business and you're investing, you got to budget for your protection planning, because you never know. I look at it like this. If you draw like a pie chart and there's 3 quadrants, the things I know, the things I don't know, and the things I don't know that I don't know. Mm-hmm. If I know something, I'd be like, hey, you're going to call me Curtis. Yeah, here's the answer. If I don't know something and I know Curtis knows, I'm like, hey, Curtis, I don't have the answer for this. You do. If I don't know that I don't know something, I'm never going to be able to ask the question. Most people own and operate their life through that portion of the pie chart. And that I don't know that I don't know. Right. That's where most catastrophic loss comes from. Shrink that portion of your pie as much as humanly possible, and then protect yourself from that portion as well. But it has to get done beforehand. And so that would be like one of my, things is just like, what portion of the pie chart are you living?
Can you all work nationally?
Yeah, we work nationally. I have clients in every state. We have over 3,000 clients nationwide. I have affiliate attorneys in every state. So if something has to get done state specific, I'll just reach out to one of my affiliates in that state.
Okay. And so tell them how to reach out to you.
Yeah, so you can just jump on my website, www.btblegal.com. I have my website set up more as an educational website. Lots of case law, lots of case studies. I'd rather have you be educated than, and know what to look for and ask proper questions while you're shopping around for this. And then you can just email me, Brian, BRIAN at btblegal.com. I do a free consultation, again, like whether you are a right client profile for me or not. I just rather you have a solid opinion, and then it'll give you good questions to ask the next person you talk to.
That's awesome. All right, guys, I'm trying to shut it down mentally, because I'm thinking about other stuff. Y'all don't know this, like the podcast is really free consulting for Curtis. So guys, this is probably one of the most important podcasts I've done in 3 years. Okay, just on this topic, because I think it's so important. There's so much misinformation out there, and so my brother, I am Brian. I'm excited to have you, and we're going to be in touch. Thanks for dropping these jewels on our listeners on the Practical Wealth Show today.
Yeah, absolutely. Thanks for having me on. It was great.
Yeah, my pleasure. All right, guys, go out there. Make sure you reach out, write some stuff down, and if he gives you a free consult, don't be, get on there and think about what you want to say. All right, and have a great day, everybody.